Well, hello everybody, and welcome to this Shape the Debate session brought to you by the Solicitors Group as part of Law 2024 Wills and Probate Online. Today's question and answer session will last an hour, and it's going to cover some pre-submitted questions. And we have me, Julie Bell, and Helen Forster. The session is sponsored by Watchman Insurance, and before we get going, I'm just going to tell you, though probably most of you are already familiar with Watchman, but I'm just going to tell you a little bit about it. Watchman is a specialist insurance policy only available to solicitors. It provides insurance for unoccupied properties and has been revolutionary in changing the way probate solicitors protect their clients' estates by reducing the initial pressure on your funds while you're still trying to access the estate and sell the property. Watchman achieves this as solicitors do not have to pay the full premium up front. Cover is secured by simply paying a small deposit and continues with a daily premium charge that is deferred until the property is eventually sold, and that's for up to a year. There's no finance agreements and no cancellation charges. It's also available for homes where clients are in care or with reduced legal capacity. Getting started and arranging cover is easy, and if you would like to learn more about Watchman, you can contact them on 01935 389812 or via their email watchman@practiceenterprise.com. So I think having done that, we're just about ready to get started. For those of you who don't know me, I'm Professor Leslie King, and all I'm going to say is that I write and lecture extensively on wills, probate, and tax matters. And I'm going to let Helen and then Julie just introduce themselves. So Helen, over to you.
Thank you very much, Leslie. Yes, everybody, my name's Helen Forster. Very nice to meet you. I am a solicitor and member of STEP, and I own my own law firm that specialises in private client matters. So anything to do with trust, tax planning, corporate protection, and of course the joys of more contentious work, which seems to happen more and more now, sadly. But that's a little bit about me.
And Julie?
Hello, I'm Julie Bell. I'm a private client solicitor based in Manchester. I have a portfolio career, so I do various training for different organisations and teaching, as well as still being in practice.
Okay, so I think we are ready to start having a look at some of these questions that have been sent in. I'm going to take the first one, and someone has said that I have said that it is wise to follow HMRC advice and obtain a professional valuation for houses. And the question is it necessary to use a valuer if no IHT is payable, perhaps because the estate is within the nil rate band or is spouse exempt? And I'm not going to give a definitive answer to that because it does depend on the circumstances. So if, for example, you had an estate which was passing entirely to the spouse, you would not be concerned about inheritance tax. And the reason that HMRC advises using a professional valuer is to avoid the risk of putting in an inaccurate IHT account, which understates the amount of tax that's due. And one of the issues, of course, is that if you do that, if you do understate the tax that's due, and the reason for the inaccuracy is a lack of care or a deliberate error, the revenue will be very quick to impose a penalty, which nobody wants. So that's why HMRC advises using a professional valuer in IHT cases to try and make sure that you're putting in a correct valuation, or if there is some argument about it at a later stage, if you've used a professional, then it's very difficult for HMRC to suggest that there was a lack of care. So obviously, if IHT is very much not an issue. From that point of view, you wouldn't need a professional valuation. But it is important to remember that IHT is not the only tax. Other taxes do exist. And for capital gains tax, for example, you might need to ascertain the value at the date of death. And so you may not need your valuation for IHT purposes, but you might need it for capital gains tax purposes. So I just say, think carefully about it. And in general, you know, even if you think your estate is within the nil rate band, if it's near the threshold, then you have got a risk that if you undervalue your property, you may be putting in an inaccurate account. So I don't know if either of you want to add anything to that or violently disagree with me. But
I think my only statement to make is we are not expert valuers ourselves, are we? So we can pass comment, but it's not for us to sort of, the validity of a difficult to asset value is not for us to say.
I think the thing about the question probably is it's drawing a distinction between the professional valuer and perhaps the estate agent who gives you an approximate figure. I suspect that was the thinking behind the question. Okay, so unless anybody wants to add anything, should we pass on to another question? So Helen, would you like to take one?
Absolutely, absolutely. So one of the questions that was posed to me was to do with, ironically, what I think probably kicks on a little bit to what we've just been talking about. And it was to do with life interest trusts, because quite often people do have them set up in a will, and then there is that question of whether or not to value it, which exactly is what you were saying about a case in point for things like capital gains tax. But the question that was posed to me was, well, does it work the same way if you set up a life interest trust into Vivos? I'm seeing a lot of this now where clients come in to see you, and I think the question is, well, Jim down the pub's passed his house into a trust, and I want to do it because that sounds great. And I see it quite a lot. I'd love to go to this pub where people get all their legal and financial advice, but this is the question, and there is this sort of have your cake and eat it ethos, I think, which is pass it into a trust. I can still live there for my lifetime, and it's going to work for all manner of taxes and care fees, and I don't need to worry about anything. And I think from my perspective, I just want to put this massive warning on. I think there are huge problems with setting up inter vivos life interest trusts. Not only will it not work for inheritance tax, I think we can all agree that if you put your family home in, it's a gift of reservation of benefit. It also won't work for the residence nil rate band, so you're reducing the maximum amount that somebody can give away down to nil rate bands, or two nil rate bands if you've got a husband and wife. But more worryingly is the inter vivos trust is in fact a relevant property trust, or what some people call discretionary tax. I get it, discretionary trust tax, but it's not, it's called relevant property, which means you're subject to your 10-year charges, you're subject to your exit charges when you do bring something out of it, and it's not as simple as just going, oh great, this will work for care. Or the other one that I've seen, and I don't know if you ladies have seen this, if I pass my house into a trust now, it won't be able to be claimed on when I die in an Inheritance Act claim. So these are the things that I'm seeing people do it for. Of course, my major concern is if we're doing anything that advertises for care fees planning, well, you can't plan to avoid care fees. Local authorities are going to jump on that really quickly. But also, it doesn't necessarily protect the asset from Inheritance Act claims either. It can be chased into, and it all depends on the reasoning and purpose behind it. So I kind of caveat these very, very much, in that in some cases it might be that it's a sensible thing to consider, but certainly when it's the family home, I think it's fraught with danger, and absolutely not would I suggest doing so just because Jim down the pub's done it. And so that's really what I'd say is, no, it's not taxed in the same way. It's taxed like discretionary trusts. It could cause you major issues. Please think very, very carefully before undertaking work such as this for a client, and massively caveat and make sure they're aware of the risks before ever proceeding. But if any of you ladies want to kick in with your views on that, it'd be greatly appreciated.
Well, I just say that I come across these quite often, and it is usually a solicitor who will say to me that they have a client who has done this. And the worst scenario is the one that you were outlining, where they've put a house into the trust, the house was worth more than the nil rate band. So you've got an initial charge to inheritance tax and then the 10-year anniversary charges. And very often when this is done, someone has sold them a scheme. That's generally the scenario, without considering the inheritance tax consequences. And one of the things that occurred to me is that very often what you actually want to do is to unpick the whole arrangement, because it is frankly disastrous and it's not going to work. And one of the things that it did occur to me that one might be able to do is to suggest rescission on the basis of mistake, where someone has actually been missold something and the risks and dangers haven't been properly explained to them. So that's all I would add.
And of course, trying to get those costs from perhaps the company that may have set it up in the first place would be...
Who has almost certainly gone bust.
Yeah.
Yes, exactly.
Okay, Julie, do you want to take a question?
So my first question is rather topical, and is looking at delays at the probate registry and the time for grants to issue. And the question is there a significant difference in the time to issue probate grants and letters of administration grants? You know, it's to encouraging people to make wills if it gets you through sooner. And the question is, you do get through sooner, but not much sooner, because we're still in a very delayed landscape. The current figures that have just come out, we're looking at probate being a painful 14 weeks, and letters of administration without a will is the next people who get through, and they're averaging at 17 weeks. Now, there is a difference of about a week between online applications and paper applications. So that is better than it has been, where paper was very slow. But for lots of intestacies, we can't apply digitally. We've got to do that paper route. And so that is going to be slower. You can only apply online at the moment for intestacies if we have one applicant and they are the only person entitled to the estate, or we have no minority interest. So unfortunately, with lots of paper applications, might be saving you about a month. So, you know, given how slow things are, a month's not bad, but it's, you know, there's no route to whiz you through.
I don't know if you saw this, but the weekend papers were absolutely full of moanings about delays at probate registries. Well, HMCTS, I suppose I should call it. But there's a lot of stuff from the charities, which is actually quite helpful, because of course charities get lots of sympathy, whereas solicitors on the whole don't. So we can complain like mad and everyone just thinks, oh, lawyers, who cares? But the charities are saying that it's causing them real problems because their funds are being held up, which is very difficult. And I think the thing is, it doesn't matter what they say about how long on average it takes, because nobody is ever average, and it's the inconsistency. I mean, I've had people who've gone, you know, I put this application in, it came back almost instantly. I fell off my chair because I'd spent so long managing the expectations of the clients, telling them, oh, you know, don't expect it for weeks, and then we suddenly got it. And then there'll be another one, which is exactly the same. There's no difference that you can see, and it just disappears into one of those black holes. And I just think it's making life incredibly difficult for solicitors at the moment. And
it feels like it's only very, very slowly improving, if at all.
Absolutely.
But now it's being discussed in Parliament a lot. Hopefully, you know, I think minds are being concentrated.
And I did see recently that they'd had a change in their management team, and they were hoping that it was going to be better after this change, but we will see.
Certainly from what I've seen, just to kind of tack on to that, it seems to be that if you submit your application and you send your kind of documents, like your will and things, down to Harlow, and they happen to get to your online application and they have the will already on the system. So if that happens all at one go, so if they happen to already have that will uploaded, they'll grant it really quickly. If though, because of their backlogs of getting the wills on that have been sent, it's not, then you kind of get a stop on, you go right back to the back of the queue again. And I think it's that seems to be causing it, because there are the occasional ones slipping through where it just all happens to have worked well. And I think that's causing even more confusion, because I see a lot on LinkedIn of colleagues and that who are going, what is this? This has been here within 4 weeks, and then I'm waiting for this other one that's been 2 or 3 months. What? And I think that's the confusion, is there doesn't appear to be any sort of set, we will look at it in this time frame to get it going. And I think that is, from what I've seen, the problem, because like you say, it's almost like Russian roulette, isn't it? You send it off, are you going to get it back? I don't know. It just seems very strange. And with this new system that HMRC have brought in, with the new 16-digit codes that you've got, again, I'm not seeing whether or not that's making an actual massive difference, because it just means that they're pre-approving the figures. Well, the probate registry aren't looking at those figures anymore anyway, because HMRC are looking at those figures. So I'm not convinced that that's going to make a big difference, but it remains to be seen. We're only in April, I guess, to see if that makes a knock-on.
I think it might make a small difference, because you did have that scenario where you'd sent your IHT 421, the revenue had told you, yes, we've sent it off to HMCTS, and then the probate side was saying, well, we haven't got it. And the revenue was saying, but we've sent it. And I watched a webinar last year from the Courts and Tribunal Service, and they said that they'd introduced a new system at that point, which was that instead of sending it, there was a sort of Dropbox idea, and the revenue put it in electronically, and in principle, both sides could see it. And so I thought, well, that sounds like a really good improvement. That'll make life better. But then people in the audiences were telling me, oh no, hasn't made it any better at all, because the revenue are still saying, it's there, we can see it. And HMCTS are going, but we can't see it. So it is possible that the codes might improve things, because at least you can, do away with that particular blockage.
And it stops the stop going on it, I suppose. But see in the long run, with the numbers of applications, whether or not it'll make a big difference.
I'll be surprised. Yes, absolutely. Fingers crossed. Okay, I've got a question now. Can you claim loss on sale relief on shares before the expiry of the 12-month period? And I suppose I'd better rewind a little bit and just talk about what loss on sale relief is. If it's normally applicable to personal representatives, but if personal representatives sell shares, quoted shares, within 12 months of the death for less than probate value, they can claim to substitute the sale price for the death value. And that will therefore reduce the amount of IHT that's payable. And it can sometimes make, quite a big difference. There's a similar relief that applies for land, but in that case, it's if you sell within 4 years at a reduced price. And the reason that those two reliefs exist is that quoted shares and land prices are somewhat volatile. They go up and down. And personal representatives are in this position of having to produce funds to pay inheritance tax, to pay legacies. And so they may be forced to sell at a relatively inopportune moment. So that's the background on why the relief exists. You can make the claim whenever you like, so you can, if you've sold some shares, reduced value, you can make your claim immediately. And the revenue do talk about this in the IHT manual, and they say that they will allow people to make the claim within 12 months of death, and they will grant it on a provisional basis, although they may have to review it later. And one of the reasons that they might be reviewing it later is that there's a lot of fiddly little bits to be careful of with loss on sale relief, and all sorts of little traps that you can fall into. And one of the little traps is that if you've sold some shares, you're the personal representative, if you then buy more shares within 2 months of that sale, then your relief is restricted. And the reason for that is that the relief isn't intended for people who simply want to change their portfolio of investments. It's intended for people who are forced to sell because they've got obligations that they have to meet. So that's one danger. And then the other danger is that if you sell some more shares within your 12-month period, it's the net position that the revenue will look at the end of the year. So I may have sold some shares today and it was for less than probate value, but maybe next week I'll sell some more shares for more than probate value, and you have to net them off against each other. So I would just say, yes, by all means, you can make your claim as soon as you like, but to just be a little bit careful and think through, am I likely to be selling any more shares within this 12-month period? Because if I am, it might be sensible to just wait and see what the final situation is. So that's all I would say about that one. And you do have to use the form, incidentally. There's a form IHT 35 for shares and IHT 38 for land. So, Julie, I think it's your turn to pick one of your questions.
Yes, so this is a question that is going to come up a lot in sort of second marriages and things. So if the deceased spouse owned a chattel, such as a car, which they use both for personal use and business use, is this going to go to the surviving spouse as a personal chattel? And you can imagine a lot of arguments here if we have something which is used for both purposes, and that the spouse is going to say it's going to come to me.
Sorry, Julie, this is on an intestacy.
It is, yes,
or I
on an
suppose
intestacy.
a gift in a will of personal chattels.
Yeah. Exactly. And so then the question is going to be, how much is it used for? Is it used primarily for business or primarily for personal use? And that is going to be the determining factor. So the sort of wording talks about used solely or mainly. So if I have if I'm a hairdresser and I have a car, which I use sort of once a month to go and see one of my clients, so I am using it for business purposes, but most of the time I'm sort of driving around using it for my day-to-day use, then that would go to my spouse on an intestacy as a personal chattel. And if I'm using it all the time for business, then unfortunately it's going to fall into residue, which the spouse will get a share of, but they're not going to get the car in its entirety.
Okay. I don't think I need to add anything to that. It seemed very comprehensive. Helen, do you want to do one of your questions?
Absolutely. So mine's going back to a bit of kind of administrative issues. Quite often people will have trusts, not just life interest trust that we mentioned earlier, but also the discretionary trust, quite often with nil rate bands. The old style pre-2008 wills had them. I'm quite an advocate of a discretionary trust in there anyway, because of the options and things it can do. And so many people say to me, well, okay, if you have a will that has this in and we want to get rid of it, or we want to alter it, do I need to do a deed of variation? And there's this sort of, I think, maybe misunderstanding of how the Inheritance Tax Act works. So the question is, if I need to take assets out of a discretionary trust within 2 years, do I need to do a deed of variation? And the short and simple answer is no, you actually don't. The difference between a deed of variation and an appointment out of trust kicks in really here. The deed of variation, of course, varies your share, doesn't it? I might inherit from Julie's estate, and I might decide, well, I don't want it. I want it to go to my own children. That's quite a common thing. And so I would execute a deed of variation to alter my share. It might be you alter an entire estate for things like tax purposes, or to put in place things that perhaps I did one the other day because the deceased sadly died very suddenly and had an aneurysm, and so we're partway through drafting a will, and so the family put in place the substituted will to execute that document. So you can do things like that, and of course a deed of variation is valid and read back into the deceased will as though that's what they did. Whereas with a deed of variation, with a discretionary trust, if you appoint out of that trust within 2 years, the same sort of thing happens if you incorporate sections 144 of the Inheritance Tax Act and sections 142 deal with these sorts of things. So deeds of variation and appointments out of trust. So in essence, if you appoint out of a discretionary trust within that 2-year window, it does the same thing as a deed of variation. You don't need to go through all of that kind of palaver of who signs it or anything else, because of course it's a trustees taking the assets out. It can make it much simpler in terms of how you deal with it. The important part, ladies and gentlemen, is really to make sure that you work out what impact that has on the estate. Because if it has an impact for tax purposes, you will need to send it to HMRC. In some cases, what I've been seeing is it's been happening kind of before month 6, so before there's any sort of tax things happening with the estate, and then somebody sending that deed of appointment off to HMRC. Well, you don't need to do that if it's not going to impact inheritance tax. They're not too interested. The point that I will make with these, though, is if you are settling into another trust, I've had one where somebody set up a disabled persons trust. We just need to think about things like the TRS, don't you, the Trust Registration Service? Because if you enter into and set up a new trust via these sorts of things, whether it's a deed of variation or a deed of appointment, who is setting that up? It's not the deceased. It'll be the trustees if you're taking it out of one trust, setting up another one, or indeed the person who's altering their inheritance in the deed of variation. And the paragraph 7 exemption for trust registration will not apply. You don't have 2 years to do that. You've only got 90 days from taking it out of that trust or taking it out via a deed of variation into a new trust. So it's basically when that document creates another trust is going to cause you a problem with the TRS as well. So I think there's a lot of things to think about, but the answer is, do you need a deed of variation? No, you don't. You don't need to worry about altering and putting in a whole new substituted will to build in something and get rid of a discretionary trust. You very simply just appoint the assets out and incorporate your section 144 of the Inheritance Tax Act. Don't worry necessarily about a whole deed of variation and how that's going to work with the rest of the will with a substituted will. You don't need that.
I'd just add, actually, that it's not even that you don't need it, it's that sometimes you could not achieve what you want to achieve with a deed of variation, because beneficiaries can only deal with trust property under the rule in Saunders and Vautier. So they have to be of full age and capacity, and between them entitled to the whole beneficial interest. And with most discretionary trusts, you will have unborn or unascertained beneficiaries. And I had a lovely one once. I was talking to somebody and she was saying that she was going to do a post-death variation to get rid of this nil rate band discretionary trust. So I said, oh, well, I'd be surprised if you can use a deed of variation. And I explained, because, you know, you've got to have all your beneficiaries agreeing. And she said, oh, it's fine. It's the spouse and children and grandchildren, but there aren't any grandchildren at the moment. Well, you know, the point is that the class is open and the grandchildren could be added. And so you couldn't do it with a post-death variation. But of course, as you say, the trustees can do the appointments out. And it is easier, because I always find people are very unwilling to do a section 144 appointment. They would prefer to do a variation. But I think that's just because they're more familiar. And the other thing I've often had is people saying, well, I've gone through all the precedents and I can't find one for a section 144 appointment. And the thing is, you won't, because all it is an appointment out of the trust. And if it's within 2 years of death, it is automatically read back under section 144. And that is also one of the very, very, very common traps that people fall into, that section 144 is automatic. And anything that you do that changes the terms of a relevant property trust within 2 years of death is read back. And so it's very, very easy to give somebody a right to income within 2 years of death, not realizing that the effect of doing that is that it will be read back to the date of death and create an IPD. And while there's nothing wrong with creating an IPD if that's what you want to do, if you didn't want to do that, if you wanted to keep your discretionary trust going and you just wanted to give somebody income, then it's disastrous. And so what you need to do in that situation is you can give people income during the 2 years following death, but don't give them a right to the income until the 2 years has elapsed. And then what you do will not be read back. Julie, did you want to?
No, nothing to add to that. That was comprehensive.
So I just want to say one other thing, in that somebody asked me this the other day on a course. They said, can you, and I think it's valid for what we're saying here, they said, can you specifically disapply the rules for the readback in the same way that you can limit the length of time of a trust? So instead of it being, 125 years, and there's a question later on this, and limiting your discretionary trust, can you actually disapply the Inheritance Act Section 144? I think it's an interesting point, isn't it? That there's, I think, this misconstrual of how it actually works. Because my answer is, well, no, you can't actually.
That's right.
You can want to do it all you want. You can put it in. It's not going to work. But I think it's this misunderstanding of, well, we can disapply this rule. But just obviously cottons onto what you've been there saying there, Leslie, and that, just be aware of the danger. People think that they can skirt around it, and not. And I think the kind of, again, happy cake and eat it approach with flexible discretionary trusts where you can do this, this, and this. I think there's some massive dangers of trying to create a hybrid and misunderstanding totally what's going to happen with that readback. But there we go. Be warned, everyone.
Okay, I've lost track. Is it Julie's turn? I think it is.
I think it's yours, Leslie.
Is it? Is it my turn?
Yes,
oh,
yeah,
good.
back to you.
Oh, goody. Okay. All right. I've got a good one here. A father gives his daughter £400,000 by lifetime transfer and leaves his estate by will to his second wife. How is the IHT calculated? Well, the answer to that is it depends, but if nobody thought about it when the lifetime gift was made, the rule is that if you die within 7 years, your gift becomes chargeable to inheritance tax, and it's the transferee who is responsible for the tax. So the daughter is going to be responsible for the tax on anything in excess of the nil rate band. Now, it is possible that you might have thought about it either at the time the gift was made or when you made a will. And it's one of the things that it is worthwhile when you're taking instructions for a will to check on whether or not any significant gifts have been made. Because, of course, this 400,000 might have been given to the daughter to allow her to buy a house, and she may not have any spare funds to pay the tax on that lifetime gift. Now, you could, if you wanted to, put a direction in the will to say that the tax on lifetime gifts is to be paid from the estate. So here it would be paid from the residue of the estate, which is going to the second wife. So that is perfectly possible. You'd probably have a happy daughter and a rather grumpy second wife in that situation. The other thing to be aware of in that situation is that the direction to pay the tax out of the residue of the estate, that is treated like a legacy. And so if you've got your residue going to an exempt beneficiary, you've effectively got a pecuniary legacy to the daughter, tax coming out of the residue. So it will actually have to be grossed up, which is a bit of a shame, because as somebody said to me once, you don't half increase the tax once you start grossing up, and it's true. The other thing, which, I mean, as professionals, we're not always involved when people are making lifetime gifts. But if you make your gifts in succession, So if I gave 400,000 to my daughter, and then the next year I gave 400,000 to my son, the son, unless you think about it, the son is going to come off quite badly, because most of the daughter's gift is going to be covered by a nil rate band, whereas his is mostly or entirely going to be taxable. And so he would get less benefit from the gift than the daughter. And that's probably going to lead to family irritations. So that would be a situation where you might perhaps want to direct that any tax on lifetime transfers is to be paid from the residue of the estate. Anybody else got any thoughts?
So it sort of shows the benefit of getting some legal advice. You kind of think you're doing, you know, no harm done here, and then you've got a weeping son, a sort of celebratory daughter, because he thinks he's treated them both the same because he's given no thought to it.
Yeah, and the other thing, I mean, it's difficult, isn't it? Because if you're not involved when people are making the lifetime gifts, you can't give any advice. No. But something that people are often quite bad about is they give something to their children. It's not entirely clear whether it's a gift or a loan. And at some point down the line, it may become very important whether it was a gift or a loan. And I think people often really haven't thought it through at all, and haven't thought about some of the implications of making quite substantial gifts. But as you say, Julie, we often don't get consulted, so we don't have the opportunity to give any advice.
And they try to straddle both things. Is it a gift? Is it a loan? Depends which day you ask me. Yeah. It's got to be one or the other.
Yeah, there's this feeling, well, it's a gift, but, you know, if there was a divorce, then, you know, we'd want it back. That sort of scenario. Anyway, there we go. Whose turn is it now?
Yes, I think it's mine. So on an intestacy, what actions are possible before the grant is issued? And I think some of this depends on the size of the estate, because obviously the starting point is your authority runs from the grant, which we've looked at before could be a massive delay. So potentially you shouldn't be doing anything in the interim until the grant comes through. However, I think the starting point is of any action you're doing, who is going to argue, who is going to be, hang on a minute, you know, what are you doing that with regards to administering things? So if everybody comes on board, the other people who are entitled, if you're not the person solely entitled, they're of full age, they've got capacity, then you can start divvying things up, dealing with chattels, etc. I also think the banks are remarkably relaxed, you know, on intestacies, you know, where we don't have a grant, and they're just sort of flinging money at whoever writes in, and lots of banks are at £50,000 now. So, you know, we are, you know, maybe 5 or 6 months away from having the grant, but I'm already in funds. So that's a sort of, you know, there's the actual law, and then there's reality on the ground as to what different institutions, what a relaxed approach they will take.
Yep, I was absolutely gobsmacked, really. I was doing my stepfather's estate, and I'd just gone into the bank to kind of check what he'd got, and they sent me a check more or less the following day. And I think, hang on, I can't do anything with this. I haven't opened a bank account. You know, it was a complete nightmare.
Frightening, really. Yeah,
really shocking. And I mean, it's more understandable, I think, when it's a will and an executor, although even then there's the danger that someone has got a will, but actually there's a later will. But I think to be doing it when there's an intestacy is really quite surprising. But there you go.
I would just add on to that. I had this case actually kind of arise in terms of what we should be doing. In that I had a lady contact me. She said, well, my best friend's died. She had been estranged from her family, who were adopted family. And sadly, there'd been a lot of issues with abuse and things like that when she was younger. And so she'd not spoken to them. She'd nominated her pension. She was a professor, so quite well to do. And she died from a long-term illness, cancer. She's only young. And they said, well, we're fairly certain that we are the people responsible because we've done everything with her. She'd nominated everything, we'd worked with her, etc., etc. But we can't find a will. So what do we do? And so the issue becomes, as you rightly say, well, who do we take instructions from? We don't actually know what the situation is. But in reality, what should we be doing? Well, you've got to do a will search. We're going to have to do an asset search on this one because we didn't know where everything kind of was. What do you do? So we took the standpoint of we need to take that and then to take that will search, because even if a scenario occurred where it was somebody else that ended up dealing with it, that is a sensible thing to do, and your cost should be recovered for that. I don't think there is a danger of doing that. Someone's going to have to do it. Well, in this particular instance, what actually happened was we could not locate a will. We have done a will search, we've done everything, we cannot find one. So actually adoptive mother is here, she's alive, so we've had to go to adoptive mother. And it's quite nice in essence what's happened here. So basically they've said, oh, absolutely, you carry on, you've already started, which of course from a business perspective is sensible, I guess. But secondly of all, she's actually diverting everything to the charity that this lady has nominated her pension to, saying that's the right thing to do. So you kind of do get a bit of, you know, humanity kicks in now and again, doesn't it? But I guess the point I'm making is this, you know, there's a lot of people that would turn around and say, we can't take those instructions. You need letters of administration before we can undertake any sorts of searches. But it's chicken and egg. What's the point getting a letter of administration if a will comes to light? It wouldn't make any sense. And so there has to be this practical, I think, understanding of, look, these things need to be done. In reality, let's say this lady had decided to instruct somebody else to administer. I don't think there would have been many issues at all with us going, look, here's the initial sort of bits that we'd done because we didn't know what had gone on, and here's the cost for doing that. I don't think it's unreasonable. That work was already going to have to be done. So I think there's kind of that practical, it doesn't come up very often, but usually, you know, by kind of picking up the phone to these people and going, well, this is the situation, this is what we've got, it's not really too difficult a thing. And I think as long as practitioners are actually willing to talk to each other, half the time, I think that can get missed. And so I think it's that practicality approach. So it's just something that just happened at the end of last year with one that we've got that we're now dealing with. And it just brings into, I think, into the kind of forefront of what you're saying there, in terms of you've got to be a bit sensible here and go, well, look, things do have to be done. You can't just ignore it and hope it'll go away. It needs to be dealt with. How do you do it? So it's just a really interesting point, because intestacies, they don't come up as often now. It's good to see, but they still do happen. And what do we do then? So there we go. That's all I wanted to say on that one.
There's also the point, isn't there, which I've sat through so many talks by genealogists, but they always make the point that if you've got an intestacy, do for heaven's sake make sure that you do a search to track down all the relatives, because, you know, they have all these terrifying stories of people who have distributed to the relatives they were told about, and then discovered that there were, you know, 20 or 30 cousins who were equally entitled. So I think intestacies can be very difficult.
Absolutely.
Does that make it your turn, Helen?
I think it does, yes. So I've got a question that I think is quite relevant. We've been talking about lots of different things, and I mentioned the TRS earlier. And of course, I don't think it would be a Q&A session if we didn't have the Trust Registration Service mentioned at some point. But one of the things that was mentioned was, whose responsibility is it for registering a trust on the TRS? And I think when we set up lifetime trusts, it's fairly obvious, isn't it? It's the trustee's responsibility. It's not the practitioner's responsibility. HMRC actually have an email address, which is trustenquiries@hmrc.gov.uk. And you can email them and ask for a how-to trust registration PDF, which also has little screenshots as well. It's almost like people are coloured in. It's great. So it shows you how to do it. Please don't get excited by that, ladies and gentlemen, the fact that that email address is Trust Inquiries. You can't ask questions, but you can get hold of this, and it is really quick to come back. I was teaching the other day, and somebody sent an email, and within half an hour they got the actual PDF, so it's really quick to get hold of. The responsibility is on the trustees. They decide who's going to be the lead trustee, and they undertake the trust registration. And when it comes to an administration, I think this becomes quite important, because what I've seen a lot of practitioners doing is they're advising, oh, you've got a load of will trusts, for example. These are clearly going to be here for longer than 2 years from the date of death, which is the exemption. And therefore, we'll arrange to register them as part of the administration process, and they're taking the charges. But the responsibility isn't on the executors to do that registration. It's on the trustees. So if you're taking costs from the estate as a whole to register that trust, you could have a knock-on problem because it's not actually their responsibility. You need to be telling the trustees it needs to be registered. Ultimately, they can go and do it themselves and save those costs. But really, it's a trust expense, isn't it? It's not really the estate's expense. Quite often the beneficiaries might be similar. Now, life interest trusts, I appreciate, and quite commonly they might say, fine, do it. But certainly, we've mentioned discretionary trusts here quite a bit, haven't we? And, you know, the beneficiaries can't give that sort of approval in the same way as they can in those sorts of things. So actually, taking it from things like a residuary estate where you might indeed have those minor children and bear trusts and things, I think it's going to be a massive problem. So I think it's just a word of caution of just assuming, oh, there's 4 trusts here, they all need to be registered in the TRS, we'll go ahead and charge you £250 plus VAT per registration, for example. And that's another £1,000 in your administrative costs. I think that's where this will add up as big problems moving forward. And so I think it is something to bear in mind, is whose responsibility is it? It's not the executors, it is the trustees. And please make sure that you're giving them that right advice. I personally am a big advocate of fact sheets. So, you know, having a fact sheet of these pieces of information, you need to register it, here's the link, this is what you need to do, you know, like I call it the afters, you know, the changes and things like that that need to be done. You can easily pop that on. It's good in terms of client care, but also in terms of work moving forward. They've got a list of what needs to be added. They're quite likely to come back to you, the firm, going, oh, well, I need to retire this trustee now and put this one in. You said it was something on here. Can you just do the paperwork and do that for me? So it's quite good in terms of a business sense as well. So I do think it's something that you need to think of as firms in terms of what you do with those afters and what you're advising executors and trustees about, because it gets a little bit muddled, I think, in terms of everything being dealt with in the administration as a whole. And I just think moving forward, we might see some problems.
I think that's a really good point. And, you know, I hadn't really thought about it, but yes, you're absolutely right that if you have created several trusts, you know, the costs should be coming out of those trust assets. It's different. I mean, if you've got the administration trust and your administration is still grinding on 2 years from the death, then that is the responsibility of the PRs and will properly come out of the estate. But absolutely right.
You know, if you have a vexed beneficiary who is looking for any avenue to complain, there's a great one to be going at.
Yeah.
And all the ones that are doing, not that they're all about money, I'm not saying clients are all about money, but some of them are quite, you know, they're wanting to check every penny. This is something that I foresee being something raised, because costs can vary. I've seen variations of costs from anywhere between, I've mentioned 250, I've seen one which is £450 plus VAT to register it. And if you think about, I know, don't even get me started, Leslie, but you know,
there might have been a lot of beneficiaries, I suppose.
If you think about the number of kind of trusts that could be ongoing, especially if you've got kind of minors and things like that, and the old style wills that might have them specifically named with individuals and things like that, it's just a lot of costs and things that I think are going to cause queries later. And if we don't get onto it now, we're going to have a knock-on effect later, I think, in terms of these questions. But there we go. Clients say causes fun.
Okay. Is it Julie? Julie next?
I think it's back to you, Leslie.
Is it? I'm absolutely dreadful at keeping track of whose turn it is. Okay, here we are. I've got another residence nil rate band one, which I quite liked this one. So father leaves his 3 sons his residence, which is worth 1.1 million, and the residue, which is very small, 60,000, to a discretionary trust. There's a full double nil rate band and residence nil rate band available. And the questioner says, how do I apportion the tax given there is a double residence nil rate band? Well, I could be wrong, but I think that this person may have misunderstood how the residence nil rate band works, and it is quite a common misunderstanding. The residence nil rate band is just like the ordinary nil rate band. It doesn't attach to the gift of the residence, which people often think it does. So all you do in this case is you'd say, well, what are the assets of the estate? 1.1 million residents, 60,000 of other assets. Add it up, take away the residence nil rate bands and the ordinary nil rate band, and then work out your tax. And your tax then gets paid wherever the burden is going to fall, which will usually be on the residue. So in this example, work out your tax, pay it from the residue. But you don't go, oh, this particular gift is exempt. It doesn't work like that. It's for the benefit of the estate as a whole, the residence nil rate band.
I think the residence nil rate band is a world of pain in itself, isn't it? It is a very confusing piece of legislation. So, you know, it doesn't surprise me that people can kind of get it wrong. So I'll often get asked, well, can you track it through a life interest trust? Well, yes, you can if it's spouses or civil partners. That's okay, as long as it goes to qualifying people afterwards. But yes, I think because it's called the residence nil rate band, people think the clue's in the name, don't they? And they're forgetting that that's a qualifier for it. And I think certainly in the way I advise for clients, it's easy for clients to get it into their head if you call it a property allowance, but it's not actually a property allowance. I think that's the bit that we miss sometimes as we start talking about it like that and speaking about it, and then we start thinking that that's how it works, isn't it? So I think it's something that's not uncommon, but I guess I would kind of suggest people have a look at things like HMRC have a residence nil rate band calculator, for example. That's really good for working out what allowances somebody will have, just even as a starting point. You know, do I have two? Do I have one? Somebody's partway through the taper because they're at 2.1 million. What do I do? What I would put a caveat on, though, is if you are looking at this for somebody in their lifetime, and I had this, I went onto the calculator because I wanted to see exactly how much. You've got to kill your client off today because it asks you when did they die. So technically they might not be dead, but if you're working out what they would have if they died today, that's what you've got to do. So essentially you've got to kill your client off. But it is really good because it comes up with that calculation. And then once you've got that, as Leslie says, then just start applying it, because I think that's just a really good way. And I'm seeing people use that a lot. I quite like that calculator.
It is really good. It's very straightforward. The other situation, actually, just thinking about it, where I've had questions from people who've got the allocation wrong, is where you've got a life interest in a trust and free estate. And in the free estate, there's a residence. And I had this woman who was really upset, very, you know, careful, methodical. She'd worked out her IHT, she thought completely correctly, sent it off to the revenue, and the revenue came back and said, no, you've done it wrong. And what she'd done was that she had allocated the benefit of the residence nil rate band exclusively to the free estate. And so she had paid too little inheritance tax on the free estate. And what she should have done is exactly like this question that I was just going through. You add together the property in which you have the qualifying interest in possession, your trust property, you add it to your free estate, take off your nil rate band, take off your residence nil rate band, work out your tax, and then apportion it between the trust and the free estate. And I always remember her because she was so cross. She said, well, this is really unfair because the trustees are benefiting from the fact that there's a residence in the free estate. And that, of course, is true. But the trustees benefit if the person who dies has got a full nil rate band because it reduces the overall tax bill. It's just the way it works.
Yeah. Yeah.
Okay, now I know it's not my turn now because I've just done one.
I think it's Julie's.
I think it is. So looking at bona vacantia and people coming up, sort of appearing when we think there's no person entitled, but actually there is. So the question is, how long is there to claim against an estate that has gone bona vacantia, but where there are entitled relatives, but at the time we just didn't know them, they hadn't appeared. So there's quite a long time period to pop up, and you often see in like local newspapers, you know, does anyone know Colin Smith? Obviously, if you're Smith, you're a bit harder to trace, you know, to claim against his estate. So we've got 12 years as the starting point from the death, but crucially, we have a discretionary period of up to 30 years from the date of death. So when people get retired, they can start going through those lists, and they've traced their family tree. It might be not all is not lost. And so for in our area of law, 30 years is an awful long time. That's much longer than we see in most other areas.
Just thinking about bone of Acantia estates, I don't know if you've noticed this, but there is power for discretionary payments to be made. So if you've got sort of, you know, a devoted neighbour who's done lots of stuff, you know, or there was a will that was about to be made and wasn't, you can apply for a discretionary payment. And there used to be lots and lots of guidance on the Treasury Solicitor's website, and also Duchy of Lancaster, Duchy of Cornwall. And I'd actually put that into the Probate Practitioner's Handbook. And a year or so ago, I was updating it. And so I thought, oh, I'll just see what they say now. And it's all gone. There's no guidance there at all. It just says something like, you know, you can apply for a discretionary payment. But previously, they'd gone through all the things that they would take into account. And it was very similar, actually, to if you were making a claim under the 1975 Inheritance and Family Provision Act. But I thought it was quite strange the way they had just done away with it.
Well, they're not welcoming them, are they? They're trying to be,
they're certainly
you know,
not.
if you're a cohabitee and you've been living together a year, you're high and dry, really, without that discretionary payment.
Yeah. I think we've probably got time for one or perhaps two more questions. So Helen, do you want to pick your favourite?
Absolutely. I think there's one that I have a big pet peeve about, because I do a lot of trusts and tax planning. And one of the questions that was posed to me was, can I set a trust up with nothing and then settle assets later? Now, for those of you who have done STEP, when you specifically do your trust sort of exam here, and I'd recommend, if you haven't done it, ladies and gentlemen, please look at doing that. I think what people miss is very similar to the Wills Act, where you've got certain things that have to happen in a will for a will to be valid. Well, there's trust validity requirements as well, and case law surrounding this. And one of the things that specifically has to happen is there's got to be assets that are transferred to or under the control of the trustees. They vest in them. And so the answer is, can you set something up with nothing? No, you can't. You've got to have something. And this is where a lot of people have that hypothetical £10. Well, don't make it hypothetical. I've seen some people that kind of paperclip it to the front of the trust deed. Well, I guess that's there. Okay, that's fine. Setting up a trust bank account, I appreciate at the moment. It's a bit like rocking horse poo, isn't it? I get that it's pretty tricky. So as long as you've got assets that vest, but one thing to be very careful of, like I say, I do a lot of lifetime planning, and in some of these, it might be that you're going to settle kind of 325,000 from an offshore bond. That's one of the ones I've got at the moment. So husband and wife both settling this. First things first, I've set up a trust each, rather than one trust, because they're going to be adding things to it later. And if you have one trust for the two settlors, it becomes a nightmare trying to work out your 10 years and your interest and everything when it's all lumped into one pot. So first of all, think about the admin side of things as well. What's going to be best for your client? What are they looking to do? But secondly of all, we've set it up now, and the bonds are going to be transferred later when they've got time, when they come to fruition in kind of a couple of months' time. So we've put £10 in so that they're there. Absolutely. But don't forget to take that back out if you're going to settle 325,000 in it later, because what you're going to end up with, 325,000 and £10. And so many trusts sit with this, and then they're going, well, you're already now, aren't you, before you even look at it. When you're in relevant property trust, you've got 10-year charges, you're going to have an exit charge, and you're going to have to do some maths on the IHT 100. Please make sure you take that back out, no matter what planning you're doing, because otherwise it's going to render it. Or, of course, don't settle a full 325,000 in. Take your £10 out, that sort of thing. But make sure you're looking at how that's going to work financially. And if you really are confused about these things, don't feel scared about getting a tax advisor or an accountant on board, because this is what they're there for. I wouldn't set something up like this without having some financial advice to see what's the best thing for the client. Certainly, how we're going to do any returns, if any. Have they got somebody already? Do we want to work with someone? Don't think you can do it all yourself, because quite often we miss sort of maybe the bigger picture on certain assets that are going into the trust, even capital gains tax, things like that. So there's lots and lots of things here you need to be thinking of. Never consider doing it yourself without looking at that bigger picture, ladies and gentlemen, because you can miss these without realizing. So that would be my massive caveat on setting these up. And certainly don't set them up with nothing, but think about what else is going in later.
There was a bit of a vogue, I remember, for setting trusts up with postage stamps because people were worried about having, the £10 in the safe and thinking, we don't really want to do that. So they put a load of postage stamps in an envelope.
Be more expensive than the £10 nowadays, though, Leslie.
Oh, yeah, you wouldn't be putting too many stamps in, that's for sure. Julie, do you want to do one more?
Yes, I'm in a very large building and I fear the fire alarm may go off at some point, which I've not managed to turn off. So let's just see how I get on. So a quick question on statutory trusts and what it means, and talking about entitlement between the ages of 16 and 18, and talking about the fact that marriage laws changed last year. So going forward, you cannot marry under 18, even with your parents' consent. So if we have a historic intestacy, so something that's not been sorted out, we've never realised, and we now are on second death, hang on a minute, this house is still in someone's name who died a long time ago, they died intestate, we might have to worry about the statutory trust. If various people have died, did they die at 17? Had they already married? That problem is not going to be with us going forward, because we don't have this ability to get married. And that's from February 23, just to highlight that. So it does make things simpler going forward. But with all historic intestacies, the rules of who inherited were very different. So don't assume if you've got a spouse that they get everything. Depending on how long ago it is, we could be looking at a different sharing arrangement.
I'd completely forgotten about that, the change to when you could get married.
It was very little announcement about it, I think.
I do dimly remember it, but yeah, and I had not thought about it in connection with intestacies, so that's a really useful point. Okay, I think that's probably our hour done. I'm just going to say very, very quickly, one last question, because this was on foreign assets. And it was, somebody said that they had a client, died, dealt with the administration, then discovered that they were actually entitled to a 1/3 share from their sister's estate. And although the client was domiciled here, the sister was domiciled in Ireland. And the question was, how do we deal with it? Because we've now got this entitlement. It was about £80,000 coming from Ireland, and it had some tax deducted under the Irish system. Well, there is a double tax treaty with Ireland, and the way that it would work is you'd put in your corrective account, you'd say there was an additional 80,000, which has had Irish tax paid on it, and the revenue will then give you a credit against the IHT that's due on that £83,000, because obviously if you're domiciled here, you are liable to UK inheritance tax on your worldwide assets. So the 83,000 creates an IHT liability, but you get a credit for the Irish tax that's already been deducted. So I think that's definitely us done. Thank you both very much. I've really enjoyed it and learnt something. I've just got a few bits and pieces to say to people who are watching this. This is part of, as I said at the beginning, the solicitors group online program for wills and probate, and you can still buy that complete event with the recordings of the sessions that Julie, Helen and I have done. And if you're interested in doing that, you just go to www.thesolicitorsgroup.co.uk, where you'll also find an online exhibition. And I read this and I thought, what on earth is an online exhibition? And it's just a showcase of relevant products and suppliers, but you can browse that. And that exhibition is open for anyone to visit, even if you haven't booked the entire wills and probate online package. If you do book the package, then you can claim a free 1-hour CPD webinar from the webinar learning catalogue, which apparently is worth £35 plus VAT. And finally, feedback forms will be sent out when the online package comes to an end. By completing them, you will receive your CPD certificate. And thank everybody for watching. Thank you, Helen and Julie, for joining me, and enjoy the rest of the day.
Thank you very much.
Bye.